Well, hi everyone. Welcome to Active Self-Protection Extra. Back again on John's Briefs. We're in the conference room at C2 Tactical in Scottsdale, like we always are. And I'm here with defense attorney extraordinaire Tim Forshee, the Baron of Barristers.
Extraordinaire. That can be interpreted in either direction.
And I decided, you guys know I do this from time to time. I decided I wanted to jump Tim with a question I haven't prepared him for.
Love the ambush questions, yeah.
But he mentioned it in the last video. He mentioned how, you can lose the case because it is an acting job and you're impressing the jury every time.
That's right.
And I want to talk about that with respect to you or me as the defendant.
There you go.
This is an interesting one to talk about, so let's do it.
To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below.
Jury theory is interesting.
It is.
And I have said this, I believe, some people say, jury is 12 people too stupid to get out of jury duty. No. I think the jury is a 600-year-old dragon, right? It is a 12-headed 600-year-old dragon with an IQ of 1200 that you don't know what that dragon is interested in. But you do know you're crunchy and you taste good with ketchup. So be careful, right? You don't want to stand in front of the dragon.
Nope.
Because when the dragon is stand in front of you, he just may decide that you're a snack.
Yeah.
Simple as that. And I think one of the things in jury psychology is that the juries judge defendants before they judge cases.
Oh my God, is that true?
Tell me about this.
Well, yeah, I always tell people the before that door opens from the jury room, before the jury even comes out into the courtroom, you're acting. You are being observed at every second. One of those 12 jurors is watching you. I mean, I guarantee you that one of those 12 people is looking at you. They might just do a 20-second glance at you, but somebody's looking at you the entire trial. And your facial expressions, the way you respond, the way you look at if you look at something and you have a sneering countenance on your face, it's getting picked up, right? So you are basically on stage the entire time. And the thing that people don't realize, I grew up on a farm and did all the usual farm work, and I put myself through 10 years of college as a horseshoer. So I've done the blue collar backbreaking jobs, a lot of my life. I'm telling you, I'm tireder after a 10-hour day in court than I was after 10 hours of horseshoeing, because you're just mentally exhausted. I go home, I don't want to talk to my family, I don't want to even think about the telephone. I'm just gonna sit in front of the TV for half an hour and then pass out because I just can't deal with it. You're on the entire time. And when actors talk about how hard this shoot was, I get it. I mean, it is really hard to be on all that time. It's exhausting. So it's hard for defendants to do it, but it's incredibly important.
Well, I can say it's not my life at risk. It's not my future at risk. And I go home from a day in court and my entire suit is soaked through with sweat.
You're exhausted.
I have not physically exhausted myself one iota. I have literally sat my butt and talked. And yet I am wrung out. And now imagine that from the defendant's perspective, that your entire future is
in a 2 or 3 week long trial. Yeah, it's exhausting.
So,
and then on the weekends, in between, we're putting in 13-hour days to prep for the following week of trial. So there's no break during trial.
You're killing yourself. Yeah. Now, listen, the way that you present yourself as the defendant matters.
I think I may have told you this anecdote. I don't know if we did it on camera, so tell me if we did, and I don't want to waste folks' time. But the one I always remember was when I was a second chair, so I was a young lawyer, and it was an insurance defense case. We were representing an insurance company. It was an auto case, an auto accident. Real simple case. It was a rear ender. And our client had rear-ended the car ahead of them, and the liability was completely clear. I mean, we didn't get on the brakes fast enough, and we rear-ended this car. So we admitted fault, which means we said, look, we were wrong. You can go ahead and find in favor of the plaintiff. We admit fault. We disagreed on the damages. This person was, we thought, exaggerating their damages, the whiplash, and they were, blah, 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 blah. My lower back is killing me. I can hardly do anything because of my lower back. And we said, okay, we offered X number of dollars, and they said, no, we want X times 6, and we went to trial on the value of the case. All right, week-long trial, no major, just your usual, accident reconstruction expert and a couple of witnesses, but we admitted fault, blah, 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 very simple. Goes to the jury. Jury's out, 5-6 hours, something like that. They come back.
It's pretty quick.
Defense verdict. We admitted fault. We said, we're wrong. We did this. It's just a matter of how much we owe. We think the case is worth this. They think the case is worth that. Please find closer to this. Went to the jury. Jury came back and said, we find in favor of the defendant.
$0.
And we're like, we're so happy that we just kicked ass, and our company's going to be really happy with us and all that kind of stuff. But we're like, what? How in the hell? So after the trial's over, of course, you get to talk to the jury. And the jury foreman was this nice lady, probably in her 50s. Seemed old to me at the time. I was probably in my early 30s. And she said, look, we knew that, and she used the word, she said the word bitch. She said that plaintiff was a lying little bitch. And we're like, really, why? And
Wait, what?
She claimed that she could barely move because of her lower back pain. And she came in here and she was acting all in pain and stuff like that. She wore open-toed shoes every day of the trial. Her toenail polish changed colors each day of the trial. She was clearly lying because she was doing her pedicure every night in between days of the trial. And we were like, or her husband did it for her, or she went to a mani-pedi place when trial got it. I mean, this jury seized on the fact that her toenail polish changed colors during the trial, and they knew that she was lying about her lower back injury, and that's all it took.
Wow.
So talk about observation. I would have never noticed somebody's toenail color, for God's sakes. I mean, it was just staggering. But to me, that's like the quintessential example of you better watch how you present yourself in front of a jury, because she went from, we admitted she should have got like, say, 30 grand, and she wanted like, 150 grand, but she got zero because of her toenail polish.
Yeah.
So.
Well, and this is why in criminal cases, even if you're incarcerated, they allow you to change clothes to stand in front of the jury.
Guess who buys those suits?
Yeah, well.
We do.
Yeah, the attorney does.
Yeah.
Because I want you to look decent.
That's right.
And I can tell you, I've had a trial where the defendant was in a very ill-fitting suit.
Yeah.
And I think didn't look good.
Not impressive.
Not impressive.
And and I've had clients that come in and they're just ridiculously tatted up. They've got tats all the way down to their hands. They've got tats on their neck and stuff. And it's like, and sometimes people get upset. And I say, do me a favor, wear long sleeve shirts. Okay. Well, why? I don't. Your tats are fine with me. It doesn't bother me at all. But I don't know that that's the case for all 14 people on the jury pool. So let's err on the side of caution and let's cover it up a bit. And God forbid that they've got some racist statement or something on their neck. But that's sometimes the person that you have to put in front of a jury. And if it's on their face or neck, wow, that's a really weird makeup job they've got. And the prosecution might even point it out.
Well, and
seems you're wearing makeup, Mr. Force. You understand? Is there anything under that makeup? Oh, you have tattoos. What are the tattoos? Would you wipe the makeup off? The judge might let them get away with that. You never know. So yeah.
So and listen, I've had that same thing where in that particular case, that defendant didn't testify, which is, you're right, and the jury gets an instruction. You can't hold that against him.
Correct.
That don't mean they don't hold it against him. I can't. The judge can say, do not think about pink elephants.
We know how that works.
And the jury's gonna consider what it considers.
Right.
I'm not gonna poison the waters. I have a case that I am working. Well, I'm in the process of getting into work on. That the jury in their deliberations on a first trial had a bit of a couple people decided one way, then they brokered a charge. So no, we'll acquit on first degree on this if we all agree to convict on second degree, and then they acquitted on first degree. That one's over. The second degree shows up, and a couple people went, nope, I'm not going to do it.
Wow.
And okay, wait a minute, what just happened? The jury gets to do what they do.
Yep.
And guess what? That trial's over, and the judge can't come back and go, hey, you all can't do that. You had an agreement.
The opposite of the Daniel Penny trial. So
yeah, the exact opposite
exactly
of that.
Right.
And so these kinds of things happen. They judge the defendant. They do.
Absolutely.
So now what does that mean for you as far as your preparation of the defendant?
There's a process that all trial lawyers use that we all call sandpapering. And we're going to sandpaper the hell out of your client. Now, I have some clients who are so sophisticated and intelligent, and maybe they've taken a theater class or two as well, and they might end up sandpapering me. I mean, I'm not saying I'm the world's smartest guy on this, but the average defendant will actually do mock cross-examination. That's a big one. You and I were talking before we went on camera about a client you got in one of your expert witness cases who has a bad temper.
Yeah.
Boy, I'm going to sandpaper that guy, because I'm going to hire one of my buddies to come in and act as a prosecuting attorney and just get evil with that guy. Just really do everything we can to get him to lose his temper. And let him know that he can't do that. He cannot lose his temper. That the prosecutor is going to try to goad him and poke him, and he's got to resist that and be polite and calm, because this involves a shooting, and they're alleging it was done on purpose, and we're alleging it was completely self-defense. You lose your crap on the stand and start spitting and screaming at the prosecutor, case is over. I mean, you just lost all credibility. Clearly, you're out of control. And the prosecutor wants that. So we've got to protect that. So we'll spend days or weeks sandpapering your client. And obviously that's one of the reasons these cases, it costs so much to hire a lawyer. We're not just putting it all in the bank. I mean, we spend a lot of time doing this preparation and really grooming the defendant and making sure they understand what's going to happen and having them prepared for it. And it takes a lot of work. I mean, that's days and days in the conference room. Yeah.
Of work. And I've said this 100 times. The number one thing you cannot be as a defendant in a self-defense trial is angry.
Absolutely. And people don't remember that.
And I'm not just talking about on the stand. You can't you're the one, you have a right to face your accusers. And so you're going to be sitting there at the defense table listening to everyone else talk about what a piece of crap you are, talk all the police officers about what a bad job you did. And if you think that you're sitting there in a vacuum and you can, you know, and at the cops, nah, man, there's always a juror watching.
And not even that, but people forget, okay, there's a lunch break. You know, from 11:30 to 1, we're going to take a lunch break. Well, everybody goes to the courthouse cafeteria if they eat. I usually don't eat, but if you eat, you're going to go down to the cafeteria. Guess who's in the same cafeteria?
Yeah.
Jurors.
Jurors are sitting there.
They're sitting over there together, sequestered, but they can sure see 20 yards away on the other side when you're losing your shit with your wife and you're yelling at your kids and stuff. I mean, and I'm telling you guys, that loses cases. It just loses cases.
So I would say, rule number 1, stay out of gunfights. Okay?
Amen.
Don't stand in front of the dragon.
Amen.
The best way is don't stand in front of the dragon. If you have to, and it seems like 2025, I'm getting more and more of these cases. I got like 5 on the docket right now, and it's a lot.
It's going to get worse. Your name's getting out there even more,
Yeah,
so be
well,
prepared.
it's gratifying work. I enjoy doing it. I like helping good people. Number 1, you got to show up to court. Hopefully you did the right thing. And that's the most important thing. But number 2, you better show up to court looking like somebody that people can trust. And looking good and appropriately dressed. And it doesn't mean you got to go and buy a Tiffany, you know, a big expensive Neiman
everybody
Marcus
can see
suit.
how dumpy I am. I'm far from a clothes horse, but I mean, you might have somebody else go to the store and buy clothes for your client instead of you. I mean, I'm not very good at that, so I usually have somebody else that I know who's a clothes horse go help them with that. So
go help, you know, and so you show up looking good, and then you've got to show up, pay attention. You've got to show up and look like you are a good person the whole time. When you get on the stand, you can show emotion.
Of course. I mean, in fact, a lack of emotion can oftentimes be very bad.
Right.
There's certain things you absolutely should be emotional about.
I think it was one of the most important parts of his case when Kyle Rittenhouse was on the stand that he showed genuine just grief over what happened.
Yeah, absolutely.
And I think that was an important part of the jury finding.
And it was obviously
guilty.
heartfelt.
Yeah. And because it was honest. You can't, no alligator tears, okay?
And I know, John and I know this, but some of you watching might not know this, but we're talking about you being on the stand and showing emotion and the way you should be dressed. And guys, in a self-defense case, I will tell you right now that the typical lawyer will tell you that in any criminal case, I don't put my client on the stand. I'm not going to allow the state to score points on cross-examination. I'm not going to run the risk that my client loses his temper on cross-examination. We're going to plead the fifth. We're not going to take the stand. And that's common wisdom in, I would say, 85% of defense cases. In self-defense cases, I've not yet had one where we didn't want to put the client on the stand.
You have to.
You have to explain how you were in fear for your life. You can't let other people infer that because we can't. That we're not allowed to say what your state of mind was. You have to convince the jury that they too would have been in fear for their life if they'd been in your situation. You've got to testify. And that's why we spend so much time and effort preparing them for that, sandpapering.
In fact, in a lot of cases, you won't get a self-defense instruction to the jury if the defendant doesn't testify. I had a case where we got that instruction regardless because the defendant was on the phone with 911 when he used deadly force, so I can strongly infer his state of mind from that. I told him. I told him in pretrial, I said, man, you got to testify. He says, no, I'm not going to. I don't want to take the beating from the prosecutor. I said, man.
It's a better beating than you're going to get in the shower room in prison.
I said, your chances of acquittal here, if you can explain to the jury why you did what you did, is so much higher than leaving it with me. Because usually the expert for the defense is going to be the last guy that testifies before they close. And so, other than the defendant, right? So if it ain't me at the end, it's you at the end, and I can tee it up for you and give the jury what's up what, but you got to tell them your mindset. He said no, and it didn't work out for him. And that happens now.
Bad gamble.
He wasn't convicted of murder, which he was charged with, but they did convict him of voluntary manslaughter. And
15 years or so.
Yeah, he got 7. But it's.
He's going to have some prison cuddles. So,
So anyhow, I think that as the defendant, how you present yourself matters. And so one of the reasons that you pay so much for an attorney is they prep you for that. And they help you to overcome that.
They better. And if they're not, you better bring it up why they're not. Because that's you need that help. I don't care who you are, how polished you are, we can always polish you better. So.
And it's from the moment that you're talking to the prosecutor, you're talking to the detectives. Guess what? Your demeanor matters. Your approach matters.
I have a homicide case I'm working on now. Very sad case. I won't say the details. It hasn't been played out yet. But I'm having an interview this week, and we've got to make sure that my client is prepared for that interview. We're not going to coach him on what to say. We're not going to tell him to lie, obviously.
No.
But the way he comes across, he might not realize how emotion shows in this arena versus that arena, et cetera, et cetera. So yeah, even before an initial interview with a police officer, that's something you work through, absolutely.
Your attorney should not ever, and really cannot, tell you what to say.
No.
That's can be suborning perjury. That's bad. But they sure can tell you how to say. And how to present yourself and help you to do that. So that's important. And the juries judge defendants before they judge cases, which if you've been a fan of Asp for any length of time, this is why you hear me hammer on being a good, sane, sober, moral, prudent person. Because if you are that person, then you only have to be yourself.
And the honest thing is if you're in trial, then somebody didn't buy that.
Yeah.
So, somebody from the state, assumedly a professional, intelligent person, has decided that you're not, all the reasonably prudent person, that you screwed up. So you're already behind the 8 ball. So you're already fighting an uphill battle, obviously.
So be cautious of that and recognize that for what it is. They judge you first. So you want to be somebody that says, no, that's a good person. And this is wrong all the way around. Because the jury's going to look at you before they look at the facts. Tim, thanks for the
This is all of your potentially future defense attorneys talking right now. Please don't get tattoos above the neckline or below the wrist line, please, because it's going to make some juries upset about it. And you can put all the ink you want to, but let's not have a spider crawling up your neck when you're standing in front of a jury telling them how you're a wonderful person, because there's people who prejudge that. So
yeah, the face tats with political messages. I don't even care what the political messages are.
Yeah.
They're just going to prejudice jurors, and I'm obviously pro-tattoo, right?
Yeah,
I've got
no worries.
several that are visible, but if you do notice, they are coverable so that when I'm wearing a suit in court, you don't get to see them.
do we have time for one more 2-minute,
Sure.
90-second anecdote? So when I was a judge, one of my favorite cases, it was a misdemeanor prostitution case. And the young lady came into my courtroom for sentencing. And
What would a felony prostitution case look like? That would be a lot of prostitution. Anyways, go ahead.
I think this was like solicitation or something, but it was a prostitution-oriented case. I can't remember which statute it was, but it's a misdemeanor in Arizona. Anyway, she came to me for sentencing, and in Arizona, Class 1 misdemeanor, the most I can possibly give her, which I never did in 14 years, is 6 months in jail, right? So she's looking at probably a few days in jail, right? So she comes up, probably in her early 20s, mid 20s, attractively dressed. She had on like a black dress, and it wasn't low cut at all. It was I don't know, Mike would tell you, what's the cut where it comes down like this?
Yeah.
Anyway, it was but I could tell that she had a necklace of some sort on it. She come up to the bench to get sentenced. I realized it wasn't a necklace; it was a necklace tattoo. And she's, again, here on prostitution charges. And the tattoo was in Gothic script, and I'm not making this up. I swear to God, it said "F money, bitch."
Wow.
That's what and she could have easily worn a higher collared dress, but she was completely oblivious to the fact that she's standing in front of a judge, an old white man judge for that matter, and she's got that necklace tattoo when she's in front of the judge on a prostitution case. And that's always my quintessential example of, could you be a more clueless defendant?
Right.
I mean, so.
And Your Honor, did that have any bearing?
I hope not. I tried not to let it have any bearing. I don't think it changed my sentence decision, but I still tell the story.
And listen, we draw our judges from the pool of the human race.
Yep.
And the human brain is built to make value judgments. And those judgments, for good or not good, that's whether or not you believe that is endowed by your creator as a survival instinct or is an evolutionary process. I'm not here to have that argument today. Human beings do that. We prejudge, and we do that as a survival tool.
That's right. And if you say I'm not prejudiced in any way, you probably wouldn't live very long.
Yeah. Cognitive biases affect us all. To say, well, we want to remove cognitive bias from judges.
Yeah.
We would rather not have humans, is what we're doing there.
Exactly.
And so those kinds of things matter, especially when you can cover it up.
Yeah.
Especially when all it took was just a higher neck, or just getting the sleeves down to here. And I know somebody's going to go, well, then, John, why don't you get a haircut? Because some people don't like long hair. There are limits to
I think
those
you're out of the
things.
woods on that one now.
Yeah, I think, we'll see about
Although
that.
now that I'm up close, I do see the Boy George resemblance. It's astonishing.
Gosh, do you really want to hurt me? Anyhow, guys, be a good defendant, and that will hopefully keep you out of trial. And if you do end up getting to trial, which sometimes you can get a completely obstreperous prosecutor that you're going to go to trial, then you present the best case to the jury, and the best case is you, 100%.
Amen.
Thanks, man.
Thanks, buddy. Always.
Oh, that's fun.
So those are always, you're always worried about getting ambushed, but those always end up being the funnest ones. So.
Yeah.